Well, hello everyone, and welcome to this Federalist Society virtual event. I'm Caroline Bryant, and I'm the Associate Director of Practice Groups with the Federalist Society. Today, we're excited to host this webinar on Executive Power Under Fire, the Biden administration's response to Houthi attacks. Our moderator today is Nitin Nainani. Nitin is a law clerk on the District Court for the Southern District of Florida. He is a recent graduate from Cornell Law School, where he served as president of Cornell's Federalist Society chapter. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. After our speakers give their presentations, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window. We will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers, not the Federalist Society. With that, Nitin, thank you for joining us today, and the floor is yours.
Thank you, Caroline, and to everyone joining us this afternoon, welcome. I'm excited to host today's conversation on the legal dilemmas about executive authority with respect to the Biden administration's counter-Houthi mission. Now, this is a topical discussion because just yesterday, the U.S. military conducted airstrikes on several Houthi weapon storage facilities in Yemen. As Secretary Austin noted, these airstrikes had been authorized at President Biden's direction. Yesterday's strikes mark the latest of several since mid-January that have targeted the Houthi militants. The Houthis have conducted dozens of missile and drone attacks on commercial and military vessels in the Red Sea in what they've characterized as a response to the Israel-Hamas war. Those attacks have caused supply chain disruptions worldwide. While Biden has gotten bipartisan support on Capitol Hill for his approach, a growing number of bipartisan lawmakers, ranging from Pramila Jayapal to Marjorie Taylor Greene, have also questioned the president's legal authorities for ordering these strikes. Today's panel will evaluate the Biden administration's legal footing, but I'll start first by introducing our distinguished guests, after which we'll get into directed Q&A. To reiterate what's already been said, audience members are encouraged to leave questions in the Q&A box, and if your question lines up with the ones I'm asking, I'll try and incorporate it during the structured questions portion. But if not, I'll make a point to get to it later in the program. Now, without further ado, I'm honored to introduce today's guest, Mr. Stephen Engel, and Professor Saikrishna Prakash. In a career spanning both public and private practice, Mr. Stephen Engel is a leading litigator and counselor. Until recently, he served as the Assistant Attorney General for the Department of Justice's Office of Legal Counsel. As head of that office, Mr. Engel served as the Chief Counsel to the Attorney General and a Principal Legal Advisor to the Executive Branch, providing legal advice to the President and Cabinet Secretaries on the most critical constitutional and statutory questions, including on matters relating to national security, congressional oversight, and executive orders. In December 2020, Mr. Engel was awarded the DOJ's highest honor, the Edmund J. Randolph Award, for outstanding service to the department. Before his appointment as Assistant Attorney General in 2017, Mr. Engel had been a partner at Dechert since 2009 and previously served as the Deputy Assistant Attorney General for the Department of Justice's Office of Legal Counsel. He clerked on the U.S. Supreme Court for Justice Anthony Kennedy and on the U.S. Court of Appeals for the Ninth Circuit for Judge Alex Kaczynski. He has frequently commentated on legal subjects in numerous publications, has appeared on national news programs as an analyst, and has testified on several occasions before congressional committees as well. Professor Prakash teaches constitutional law, foreign relations law, and presidential powers at the University of Virginia Law School. His scholarship focuses on the separation of powers, particularly executive powers. His most recent book, The Living Presidency, an Originalist Argument Against Its Ever-Expanding Powers, was published in 2020, and he also authored Imperial from the Beginning, the Constitution of the Original Executive, which considered the presidency of the founders. Professor Prakash has written over 75 law review articles, published op-eds in popular newspapers, and has testified before Congress on matters of presidential removal, the Mueller report, and ways that Congress can check the presidency. After graduating from Stanford University and Yale Law School, Professor Prakash clerked for Judge Silverman on the U.S. Court of Appeals for the D.C. Circuit and for Justice Clarence Thomas of the U.S. Supreme Court. He has served as a visiting professor at the University of Illinois College of Law and as an associate professor at Boston University School of Law. He then spent several years at the University of San Diego School of Law as the Herzog Research Professor of Law. Professor Prakash has been a visiting professor at Northwestern and the University of Chicago, and he has also served as a James Madison Fellow at Princeton University and visiting research fellow at the Hoover Institute of War and Peace at Stanford University. Professor Prakash, Mr. Engel, thank you for joining us today.
Sure. Thank you for having us.
Great to be here.
So I want to get started today first by talking about the war powers framework within our system. Obviously, the framers of the Constitution divided war powers between the Congress and the President. Article 1 grants Congress powers related to the use of force, including the powers to declare war, raise and support the Army, and provide for the Navy and regulate the armed forces. And under Article 2, the President is the Commander-in-Chief. So when presidents have used force, they've generally cited two sources that would either be congressional authority or implied authorities. While I'd like to touch on both of those sources, let's start with the congressional authorization. When presidents have relied on congressional authorization for the use of force since 9/11, they've typically cited either the 2001 AUMF, which pertained to those attacks, or the 2002 AUMF, which relates to Iraq. Ultimately, though, the scope of the president's power comes down to statutory interpretation. And Professor Prakash, I'd like to start with you. I'm wondering if there are examples of how recent administrations might have interpreted these differently or more broadly than how Congress might have envisioned at the time those were passed.
Well, it's a great question, Nitin. I'm not sure the statutory question is relevant here because my understanding is the Biden administration is not relying upon any statute for what it's doing in Yemen, although there is a statute that is arguably relevant to at least some of what's going on there. I think it was relevant with respect to attacking, ISIS in Iraq, because there was a claim that ISIS was not part of Al-Qaeda. Under the 2001 AUMF, any part of Al-Qaeda would have been targetable as an entity that conducted the strikes on 9/11. And then there was a claim that perhaps ISIS was part of Al-Qaeda, an offshoot, and therefore ought to be covered. Then there was a separate claim that because ISIS is in Iraq, it's covered by the 2002 AUMF. And there were, of course, people that criticized both of those claims, arguing that ISIS shouldn't be covered by the 2001 AUMF, and the 2002 AUMF is really focused on Saddam Hussein, not any ongoing threat from Iraq that would emerge decades, if not centuries later. So in the past, presidents have, and their legal advisors have tried to claim these two statutes as sources of authority by basically, trying to use a belt and suspenders approach. They try to use statutes when they can, but they also try to cite the Constitution. In this case, I think they're only relying upon the Constitution, as I understand it. I mentioned a statute that's relevant. There's a statute on the books that authorizes the use of force against pirates on the high seas. And it seems to me that's relevant. I don't know if they've cited it or not. It would be at least relevant to attacking them when they're on the high seas. It obviously wouldn't be relevant to attacking them in Yemen.
And so, Mr. Engel, over to you. Irrespective of the congressional authorization, presidents really have claimed, to act within inherent Article 2 authorities. Have, lower courts or the Supreme Court weighed in here to help determine the outer limits of the president's inherent authority? Why or why not? And if they haven't, then kind of what governs or decides how the branches distribute the war powers between them?
Yeah, no, I think that's a great question. The short answer is no. There are no court decisions that have addressed this directly. The more complicated answer is that that there are cases, even dating back to the Marshall Court, in which the Supreme Court has addressed a variety of issues related to the scope of the commander-in-chief authority or the power of the president to engage in hostilities abroad, often in disputes over things like prizes and the like. And And then there's dictum in Supreme Court cases in the 20th century and the 21st century that sort of addresses some of these issues. And so executive advisors, are not approaching these questions, legal advisors, from the standpoint of looking at what's the controlling Supreme Court precedent on the subject, because these questions are largely not justiciable, and frankly, that's probably a good thing. But they are looking at guidance from the courts to the extent that it's relevant to the scope. But much of the kind of the law on these questions, arises from historical precedents as well as executive branch opinions. The president takes an oath to the Constitution, just as judges and justices do. And presidents over time have sort of sought to sort of faithfully kind of apply that, some, better than others, I think. And so when the Biden administration or the Trump administration or whatnot looks at these questions, they are approaching them through the lens of precedent, both judicial to the extent that dictum or otherwise is helpful, as well as sort of executive precedents from OLC, attorneys general, and the like.
So, I mean, since World War II, the trend really has been that presidential war powers, have just, expanded further. And I think the kind of most notable attempt at reform might have been in 1973, when a bipartisan supermajority passed the War Powers Resolution, over President Nixon's veto. Professor Prakash, back over to you. What's the scope of the president's Article 2 powers under the War Powers Resolution? And what sort of limits or requirements does it place on the presidency ultimately?
Great question, Nitin. The War Powers Resolution reflects an older conception of war powers. You said earlier that the war power is shared. I think earlier conceptions is that it wasn't, right? Marshall actually says in the case called Talbot versus Seaman that the whole war power is vested in Congress. And there is no early practice of presidents declaring that they could wage war without congressional authorization. Every early conflict is done with congressional authorization. That's the war with the Indian tribes, the war with France, the 1812 war, war with Tripoli, which has been mentioned in this context, the war with Algeria. And of course, you can go all the way to World War II, where we are attacked 5 times, or 5 nations declare war on the United States, and every single time they go to Congress. Sort of Korea is a break from that, and that's the sort of practice that you're referring to. Since Korea, presidents have claimed the authority to use military force to wage war, as it were, against foreign nations without having to go to Congress. Sometimes it's because the other nation is attacked, but of course that was no less true in World War II. And other times it's the U.S. is being the aggressor, so to speak. And what's happened over time is that the presidents cite to this practice as putting a gloss on Article 2, citing Justice Frankfurter's opinion in the Youngstown steel seizure case. And there is a bipartisan consensus amongst executive branch lawyers that the president now has acquired a certain Article 2 authority to use force overseas. It's disputed how much force can be used. I think that Republican OLC lawyers tend to have a broader view than the Democratic lawyers tend to have. But interestingly enough, they all cite Korea as an example of a conflict where the president didn't get any congressional authority prior to engaging in war versus North Korea and China. And of course, that's a massive land battle. So if that's constitutional, it's hard to see what's outside the scope of the vesting clause. So to go back to your actual question, the War Powers Act reflects that view. And it tries to cabin the president's authority by stating that the president can't, introduce troops into hostilities except under 3 conditions, that turn on Congress authorizing the use of force, or another nation attacking the United States. And then it has a follow-on provision that talks about withdrawing the troops from hostilities within 60 or 90 days, unless Congress has authorized the continued presence of U.S. troops in those hostilities. And so there's a constitutional question, and then there's a separate statutory question. And most of the, some of the members of Congress were really focused on the first question, which is the constitutional question. And of course, as I mentioned earlier, the folks who work in the executive branch, I believe Steve included, have concluded that practice has put a gloss on executive power. I'll stop there because I'm sure Steve has things to say as well.
And I was going to go back to him because I think he's, well suited to answer my next question, which, I mentioned earlier that the War Powers Resolution passed despite President Nixon's veto, because his administration, held a broader interpretation of, his authority as opposed to what Congress had codified in the legislation. And administrations of both parties since then have continued to challenge the War Powers Resolution, but the OLC has articulated a two-part test for determining when the president has authority to use force without congressional authorization. And I'm hoping you can mention to our viewers what the kind of standard is, and flesh out kind of either of those kind of two components.
Sure. And let me just sort of answer this in a few different ways. I think Professor Prakash, I actually have great admiration for his work, and we certainly relied upon his work both on these issues and other issues, even if the views of the Department of Justice are not necessarily entirely aligned. But I think that that the Office of Legal Counsel sort of their view, and speaking at least from my view, is that there is a degree of shared authority, and I think actually that the early history is a little bit more complicated than Professor Prakash may describe it, even though there's a recognition that when it comes to declaring war, that is clearly a decision that the founders vested in the Constitution. There are conflicts and uses of force falling short of that that have historically, starting in the Washington administration, been engaged in without express congressional authorization. And I think it is also fair to say that there's been a gloss put, over the last, 225 years as well, in which there has been a move in the direction of the executive when it comes to the nature of those scope, of those conflicts. I don't know that while the Korean War is cited by the Office of Legal Counsel, I don't know that the test that's used, if it were taken seriously, that the Korean War was fully within the president's authority, would kind of fall by the wayside. And so the current view, and in the view of the Nixon administration, frankly, and the late Chief Justice Rehnquist, when he was the head of the Office of Legal Counsel, recognized that there was a balance, that there have been well over 100 instances of the president deploying the use of forces in a variety of contexts without express congressional authorization on the front end. On the other hand, that there is a negative implication coming from the Declare War Clause that suggests that there comes a point at which congressional authorization is required. And and from the standpoint of where OLC is, OLC has looked at, as in that you suggested, a two-part test. The first part, which I personally don't think is much in the way of a limitation, calls for articulating the national interest that the president has identified supports the action. There's a long list of national interests that presidents have historically relied upon. And I think to some degree in the executive branch, it's a way of situating the contemplated military action within the historical precedents of what prior presidents have done. I don't really think it's certainly not that OLC is being asked to identify and evaluate whether this is an important national interest or not. And so I think it's kind of significant that the president articulates the purpose of the engagement and identifies that interest. I think it's something that the president reports to Congress as well as to the public. But there is a list of those interests. The second part is where, at least from the executive branch's view, more of the work is done, which is about whether the contemplated military engagement is of a nature, scope, and duration that would be what we would rise to the level of a war. That the executive branch would take the view it would would require congressional authorization, and it's not while the executive branch is not and the Department of Justice is not completely neutral on the questions, and certainly the president gets the benefit of the doubt. It actually is a question that is discussed, in my experience, within the executive branch, what is the nature of this? And so just for example, something that came across, a couple of things that came across my desk, one involving the use of airstrikes in Syria in response to Assad's deployment of chemical weapons. We actually had a similar question arise with respect to strikes against Soleimani, at the end of the, towards the end of 2020, in the fourth year of the president's administration. There was a lot of robust discussion about what are the consequences of this contemplated operation. In the Syria case, which wasn't a hard case from the executive branch, there were the presence of Russian and Iranian troops in Syria at the time, and there was serious discussion about the risks of escalation, and there was analysis of intelligence reports and the like about how do we expect the Russians and the Iranians to respond? What's the nature of the operation? Is it an operation that is likely to deconflict and not lead to Russian deaths in particular? I think there's probably less concern potentially about escalation with the Iranians, particularly given the reality of the hostilities that have existed and erupted over time. But these were questions that were considered not just as a policy matter, as they should be, but also by the lawyers in the administration. And there were presentations and analysis about expected risks. And the same thing happened in the Soleimani strike, where, of course, we were actually literally taking action against a very senior military official in the Iranian government. And so there was a judgment about is the president bringing us into an actual kind of prolonged engagement or a war with Iran, or is that not likely to happen? And the judgment was that was not likely to happen under those circumstances, where he was hit in the context of assisting operations against the United States, and he was actually in Iraq at the time of the operation. And there was a distinction drawn between what that would mean versus striking him in Tehran, which maybe they might have, not saying that they couldn't have done it, but that was significant to the calculus. And so this nature, scope, and duration test is where a lot of the work is done within the executive branch when it comes to contemplated military actions.
Yeah, I really appreciate kind of the thoroughness of your answer there. And I want to switch gears a little bit. So we're now applying this framework to the current campaign that the Biden administration is overseeing. Professor Michael Ramsey, in a recent blog post of his, mentioned that he's not entirely sure that the declare war clause is even applicable here, because the Houthis aren't a sovereign entity. I mean, they're a recognized terrorist organization, but ultimately they're a non-state actor. And Professor Prakash and Mr. Engel, I'll also give you a chance to weigh in if you'd like. I was hoping you could weigh in on this view.
Yeah, so Mike is a friend of mine and a co-author, and he's very smart. And obviously the central motivating example for war power, the declare war clause, is sovereign nations. And so he's asking whether the declare war clause applies. And I think he suggests that it's not certain, and I think that's probably right. Having said that, the more general question is, what authority does the president have to use military force without a congressional authorization? Which you might think is a question without regard to the declare war clause, right? There are other clauses in the Constitution, and I don't think it follows that a commander-in-chief can use military force just because the declare war clause might not speak to the issue. Why do I say that? Because we had a commander-in-chief under the Articles of Confederation. I don't think the office was conceived as having some independent authority to strike against other nations. And of course, the statute I mentioned earlier about piracy, or sorry, non-state actors, the statute I mentioned about piracy passed in the early part of the 19th century. It at least implies that they think that the president perhaps needs authority to use the military against pirates. And so if you want to equate the Houthis with pirates, again, the attacks on the high seas, the president has statutory authority for that, independent of any declared war, use of the declared war power. It's just a standing authority on the books. The attacks on the land aren't actually authorized, as I read those statutes, by that statute. And I think, there's a separate question of, well, even if we don't recognize the Houthis as a government, are they a de facto nation such that it's covered by the declare war clause? And I don't think just because we don't, neither we or maybe nor any other nation treats them as a nation, that fact alone isn't dispositive with respect to whether the declare war clause applies. Let me make this more obvious. If we de-recognize Germany as a nation and then we attack them, I think people wonder, like, why does this answer turn on whether or not we recognize a nation of Germany? And you might think the answer, it can't turn on that, because then the president would have authority by virtue of his recognition power to just de-recognize nations and then attack them at will.
Mr. Engel, did you want to weigh in on that at all?
Sure. Yeah, no, I think I largely agree, with that. I mean, I think the question of declaring war as a matter of domestic law is probably distinct from the one on international law. One can debate what it means to declare war under international law, which is premised upon a community of sovereign nations and the like. And I think maybe there are sort of arguments on both sides. I think as a matter of domestic law, and if you only need to look at the 2001 AUMF, I think that the nature of the sovereignty of the target, or whether it's a sovereign nation or not, of the adversary, not a lot turns on that when it comes to sort of the activation of the president's war powers. I think, the view of the executive branch would be that there is a realm of action that the president can take without congressional authorization, and that could extend towards responding to Gaddafi, or it could extend towards responding to Al Qaeda, or ISIS, or the like, or the Houthis for that matter. But I'm not sure that it necessarily turns upon the sovereignty of the group and whether it's a non-state actor or not. And of course, we have a history of we have 23 years here of going after Al Qaeda under the and its various offshoots and in Islamic jihadists, Confederates, under the 2001 AUMF, and so. I think, and we just to add to that, there's actually is legal framework with respect to the conflict against Al Qaeda that arises in cases like Hamdan and Boumediene and the like, in which the Supreme Court is assuming a law of war framework in connection with this conflict. So it's actually probably apart from the question of military operations, but when it comes to detention and interrogation and the Geneva Conventions, there actually is some precedent that suggests we actually are in an armed conflict with Al Qaeda, on that basis. So I think as a matter of domestic law, I think that's right. That it can be, and how do I know? Because, I've seen it.
So citing, and I'm going to stay with you for this question to start. Citing Article 2 powers, the Biden administration stated that it took military action specifically to degrade the Houthi capabilities to conduct further attacks against American Navy ships, but also against commercial vessels operating in the Red Sea, given the impact on global commerce. And I'd like to specifically ask about the second part, this idea of acting to protect commercial ships, which could belong to other countries, and ask whether this reflects precedent or is another expansion of presidential authority beyond what's already been asserted in the past. Is there a legal basis for defending commercial shipping?
Yeah, I think that, I think that there is history of the U.S. being committed to sort of open seas, and obviously the focus is on U.S. persons and property and U.S. ships. But, there certainly are precedents in which the U.S., particularly since World War II, but actually, even prior to that, where the U.S. Navy, sees itself as responsible for requiring open commerce, in the interests ultimately of the country. And so, I think. I don't think that the case against the Houthis is at least from a difficult one with respect to executive precedents and the like. But the idea of also trying to ensure open commerce, many of that commerce, frankly, the goods could wind up coming to U.S. ports too. It's not a situation in which the U.S. is probably looking at this as which particular ship is under fire here. But I think that's consistent with precedent.
Professor Prakash, did you want to add anything to that?
Only to say that I think it's heartening to hear Steve talk about the serious discussions that go on in the administration. My point is that if practice sets the bar for what the executive can do, and if the OLC doesn't say that the Korean conflict was unconstitutional, then what are readers to infer when they cite the Korean War as an example where the president used force without congressional authorization? On the actual test used both for the War Powers Act and for the Declare War Clause, I think the first part of the test is really kind of a fig leaf. There's never going to be a president who says, I am attacking a foreign nation and or terrorists not to advance the national interest, but to advance some private interest, right? Or to advance my election interest. They're never going to say that. And the number of interests that have been cited by the OLC are, there's so many of them that the first part of the test is really not a test that has any bite. Steve has assured us, and I take him seriously, that the second part of the test does. But again, the OLC doesn't generate the interest. The president tells them what interest he or she is pursuing, and they're always high-minded, and they're always they're never about a wag the dog situation or something like that. And I don't mean to suggest that presidents routinely are doing using force for personal or partisan reasons. It's just, my point is actually very limited, that the first part of the test has no bite. There's a lot of woof but no bark. Sorry, no bite.
How about implications if the ships are, the attacks are on ships of, a treaty ally, say a NATO ally? Would that kind of affect the calculus here at all? And I'll start with you, Professor Prakash, and then, happy to go back to Mr. Engel.
I think Steve would know more about this, but I think the OLC has said in the past that, that the president can use military force to shore up the United Nations and pursue, shore up regional stability, right, in an area far from the United States. And so I don't see why protecting international sea lanes or protecting, a part of commerce where we regularly engage in wouldn't similarly be in the national interest of the United States, right? It's certainly not a laughable argument to say that the US cares about shipping, international shipping, since we buy a lot from overseas, and of course we sell a lot, although albeit less overseas. So I just don't think that that's going to matter for purposes of the criteria that the OLC uses to decide whether it's in the national interest of the United States. I mean, let me put it this way: if the president says it's in the national interest of the United States, the OLC is never going to say it's not. That's not their bailiwick, right? They're not there to judge, and I'm sure Steve would agree with at least that point.
Yeah, and I don't. I mean, as I think I said earlier, and I think it's implicit or explicit in the Syria opinion. I don't regard, to the extent we call this a test and a two-part test, it's a matter of articulating, particularly on the first point, what the interest is involved. I don't regard OLC as evaluating that in the sense of perhaps, I suppose, if President Clinton proposed a wag the dog strategy, he'd get some pushback, but I'm confident he'd get pushback from the Pentagon as well. And they're the ones with the guns and the missiles, as well as the lawyers. So I think it's more, again, a matter of situating the use of force in the context of prior use of forces, uses of force, I should say. But look, I mean, does anyone here, and here's the question, right? So Israel, has recently been attacked by Iran, where they sent 200 ballistic missiles, over to Israel. And a few months ago, they did however many, they did 120 or the like. And the US used military force, reportedly to defend Israel. And do we believe that was unconstitutional? So I don't, there's certainly bipartisan support for that. There is, historical support for, protecting, allies and allies with a sort of little a, in the sense that I don't know that we have a formal, I'm not aware that we have a formal treaty relationship with Israel that we have with NATO, or the like. But It's not the kind of thing in which if the U.S. assists with those military operations, it is commensurate with the role that the U.S. plays in the world, in advancing its national interests, and it's something that Congress seems to be quite happy with, and quite supportive of, and so, that side of it, I think, where it doesn't go up to the notion of committing the U.S. to a full-scale war, and the like, akin to Korea, or the like. I think at least it's not controversial among the political branches.
So I want to now ask about, going back a little bit to the structure of the War Powers Resolution. I want to ask about the Biden administration's approach and the implications on the 60-day clock that the War Powers Resolution gives the president. The Biden administration has not always been precise about its thinking on these engagements, and it's been selective in what it's chosen to report to Congress. So starting with 4 occasions in which the White House has submitted notifications to Congress, which concern strikes that were authorized by the president and conducted in conjunction with the United Kingdom. The Biden administration characterized these as discrete or one-off events. If we're to take the president at its interpretation, Mr. Engel, how would that representation then affect the 60-day kind of deadline the administration has?
Yeah, I think the presidential administrations have tried to be fairly scrupulous, and this is done, by folks who do it across administrations, at the Pentagon and principally when it comes to reporting on the introduction of hostility of forces into hostilities. My expectation with these one-off is that they would not regard U.S. troops as being in, a prolonged and sustained, kind of introduction of hostilities against, the Houthis, for example, in Yemen or the like, and so that these one-offs would not trigger the clock in that way. It'd be a different story if these were sustained and, kind of, day in, day out, we were launching military operations, or much less if we had troops on the ground in these areas, in harm's way. But my guess is they've tried to be, principled in how they've been doing it, and that, where it's these one-offs. Yesterday's strikes, for example, were reportedly done by stealth bombers based in the U.S. Launched the attack and then returned to the United States. And so I think from that standpoint, they think that it's an issue worth reporting. I assume if it hasn't happened already, there will be a War Powers report sent over from that, but not a situation in which they think that they're on the clock somewhere, because as of today, there's nobody, in harm's way in Yemen, reportedly.
So I want to stay with you for this next question. Those were the cases where the Biden administration has submitted reports to Congress. In the situations where it hasn't, given kind of the OLC precedent from the 80s, it seems to be that the administration's arguing that its actions wouldn't implicate the War Powers Resolution because they haven't introduced American forces into hostilities and because they were done in self-defense. Is the administration acting within the bounds of precedent there, given some of these warships were sent to the Red Sea?
Yeah. So I haven't studied their reporting, so I don't claim to be an expert on whether they're complying or not. I would be surprised if they had departed from past precedent, to the extent that some of these operations were authorized, by the 2001 AOMF. That's not the Houthi campaign, but there they may not think they're on the clock, in that respect, because the operation is already authorized. To the extent, we're talking about just patrols, in the area that are sort of not engaged, that are not being engaged by the Houthis. They may say that that's not within the hostilities, but I don't claim to be an expert of what they've reported or have not reported, and assuming we're talking about DoD operations.
Professor Prakash, I want to give you a chance to weigh in. And I think ultimately, I think what we're getting at is, should the 60-day deadline have applied in the situation?
I think, my understanding is this sort of thought was this sort of idea that there's a set of discrete uses of force and there's not you're not involved in continuous hostilities because they're more sporadic in nature. I think the executive branch has thought about using this argument before, maybe in the context of Libya. I'm less sympathetic to it. I think it's like saying, like, imagine you have two boxers in a ring and they both have a rope-a-dope strategy, so they're barely boxing each other. Is it 60 boxing matches because they throw 60 discrete punches, or is it one boxing match? And like, I think it's, I don't think if you ask the military, not the non-lawyer part of the military, have we been engaged in 7 conflicts with the Houthis over the past, 7 sets of hostilities over the past, whatever, several months. I think they would just describe it, no, as one continuing set, although sporadic. And of course, we've had conflicts like this before, right? Where it wasn't, daily contact with the enemy. Right. The quasi-war with France, I would imagine, was something like this. I would imagine that the Revolutionary War had this aspect to it too. We weren't fighting the enemy every single day, even though we were at war with the enemy every single day. So I think I don't think it's an argument that's sort of faithful to the statute. It's just designed to avoid having to invoke the 60 or 90-day deadline, and therefore avoid having to withdraw the troops or have a fractious debate in Congress where the executive doesn't know the outcome and is fearful that, of course, that there won't be authorization, and then they'll have to withdraw or deny the constitutionality of the War Powers Act. So I think I think this is something that's not true to either the letter or the spirit of the War Powers Act.
And actually, let me just respond to that because I actually think that it is a fair criticism of the Biden administration that they have not taken the threat of the Houthis seriously over the last year, frankly. That they have been sporadic and reactive and limited, and therefore allowed there to be a sustained threat to shipping in this area, and that it sounds like they may have escalated to some degree by using, the bombers yesterday, although I don't know whether that is in fact true. I actually think that the general problem of the Biden administration strategy in this area, to the fear of escalation, the constant calls for ceasefires, and these are comments on a policy side rather than the legal side, I think may have led them to actually not engage on a regular basis, including at the Pentagon, with the Houthis, and rather to responded, with pinpricks at different times, in part because there's an incident in which they in fact hit a ship, or take a ship or the like, and there's some need to sort of have a limited, highly proportionate response in those contexts. And so, I think if there were a more sustained strategy there to actually degrade the capabilities of the Houthis rather than just kind of having a kind of tit for tat proportionate response, it might rise to the level of folks being engaged. It might, who knows, maybe it'd be over by now. But I actually think I don't think that my expectation is that the Pentagon or the White House is trying to game the War Powers Resolution here. I think they're actually just fairly reactive and engaging in kind of limited operations only when they feel like they must kind of restore some deterrence in the area, or show that they're capable of responding rather than actually ending the threat. But again, I don't claim to be an expert of the use of forces there or the like.
With that, I want to move over to some of the questions that are coming in from the audience. And as a reminder, you're welcome to submit questions in the Q&A function, and I'll hopefully get to them. Professor Prakash, I want to get to you for this question, because I think as someone at UVA, you are the best suited to answer this question. Does President Jefferson's management of the Barbary pirates provide any legal precedent for the current conflict?
Well, it's a great question, Nitin, whoever asked it. And of course, as you told me, there's an article in Politico about what Jefferson did with respect to Tripoli. And it's a very interesting episode because the administration, it's not in Jefferson's hand, but I think the naval secretary gives orders to the ships in the Mediterranean to attack Tripoli ships because Tripoli has declared war against the United States. And of course, they capture a Tripolitan ship, and then what they do is they take the cannon, throw it overboard, and release the ship. And then what the article in Politico doesn't tell us, which is kind of odd because the person's an historian, Jefferson goes to Congress and says, they've done this, and I couldn't do anything more than defend the ship. I didn't have authority to wage offensive warfare against them. That's why we let go of the ship. And he then says Congress has to act. And of course, Congress authorizes the use of force, which is an exercise of the declare war power. You can declare war without using the words, right? So whenever Congress authorizes war, it is declaring war, just like you can regulate commerce without using the word regulate or commerce. So they authorized the use of force. And of course, the Tripolitan War is fully joined at that point. Now, in that moment, Hamilton mocks Jefferson for saying that, they declared war on us, but we can't use force against them. But that, of course, is the position of the Washington administration, of which Hamilton is a prominent member of. Right? They have this view about Indian tribes that have declared war against the United States. They say this repeatedly to state governors, that Congress hasn't authorized the use of force. We can only use defensive measures against the Indian tribes. And so Hamilton was part of that earlier, and Jefferson continues to have that view. And then, as I mentioned, the War of 1812, Madison says expressly, they're at a state of war with us and we're in a state of peace with them. Congress has to decide what to do, and then Congress declares war. So the war with Tripoli is interesting because you might say that Jefferson did something that he didn't think he had legal authority to do. Publicly, he says Congress has to authorize offensive measures, and that's, of course, what Congress does. So are we to look to what he said, or are we to look at what he did? Given that what he said is consistent with what was said before and what was done afterwards, I think this is a situation where we have to at least pay attention to what he did, but we should also pay attention to what he said.
So our next question from the audience, and Mr. Engel, start with you for this one. Is there a difference in the president's authority to use defensive measures or weapons as opposed to offensive ones?
I think that there's historical support for that view, and certainly there has been an early view that when it comes to responding to attacks, there's a different question than when it comes to initiating attacks in the first instance. And so I think that's right. Now, exactly where defense ends and offense begins is not always obvious. And just to talk about some of these early historical examples, I mean, I think, we talk about defensive measures of the Washington administration against, the Wabash tribes. What exactly, to some degree, we're often talking about restoring deterrence in these contexts. And so, it's not a matter of, catching the arrows with shields. It's actually responding to attacks appropriately to neutralize a threat, that was commenced. And likewise with, if we want to talk about Tripoli, and I think, Professor Prakash, indicated this, we said, well, if they declare war against us, we're going to seize, actually, we're going to distribute your force so as to best to protect our commerce and chastise their insolence by sinking, burning, or destroying their ships and vessels wherever you shall find them. Is that defensive because they started it? Or, is that, offensive? So I think it's a little bit blurry, but I think, it is true that when it comes to repelling attacks or responding in the emergency context in which U.S. is under fire, certainly it seems like, I'll say a no-brainer, but there'd be very few people who would challenge the ability of the president to unilaterally defend U.S. persons, property, and territory, and then the like, even those who criticize, more offensive or unilateral actions.
Professor Prakash, did you want to add anything to that?
I mean, I think Steve's absolutely right. There is this discussion in the early, period about defensive measures versus offensive measures, and they don't then catalog, these are the 6 things you can do defensively, and these are the 8 things you can't do offensively. And I would agree with Steve's characterization that Jefferson's, the orders from the Naval Secretary are very broad, right? And they don't sound purely defensive. My point is that when he goes to Congress, he describes it as purely defensive, and he says, I couldn't use offensive measures. So he's publicly, adhering to a line that he may not have adhered to in private. I think, I agree with Steve that, there is this line, at least in the past. In the present, I don't really know that the line makes any difference, because if you think that you can start a conflict and say that it's not war, and therefore the president has constitutional authority by virtue of the gloss of history, well, then why wouldn't you think that the president, by virtue of the gloss of history, also has a power to respond to attacks, right? Independent of whatever the original Constitution meant. Because, ultimately the government's, and this is cross-government, the government's claim is that the history proves that the president can do something, that presidents have done something over and over again. So whatever the rule was in the past just doesn't matter. What matters is what's been going on for the last 50 or 100 years. And again, if you can start a war, of course you can respond to an attack. That's what makes, this won't matter to, I think, executive branch lawyers, right? If we're attacked, of course we can respond in kind, not only by sinking the attackers, but also by launching strikes on ammunition depots in Yemen. I don't think it's and of course they'll go through the analysis that Steve mentioned, and there's serious lawyers in both Republican and Democratic administrations, but I don't imagine that it took them a lot of time to figure out that they could do this.
So our next question from the audience, and I'll stay with you for this, Professor Prakash. The US hasn't declared war upon another nation since the Second World War, rendering the declare war clause irrelevant in modern times. Congressional control of executive military action since that time seemed to have been exercised under its spending authority, most notably at the end of the Vietnam War. So is the spending authority clause the sole real congressional constraint on executive military action then?
I think I'll challenge the premise and come to the question. Again, to say that we haven't declared war since the World War II is just misunderstanding what the declare war clause means. In the 18th century, most nations declared war without using a formal declaration of war, but they were understood to declare war nonetheless. An attack on a foreign nation was the most and strongest and clearest declaration of war, right? The first British Prime Minister said, of late, most of our declarations have been from the mouths of cannons. So they had a functional view of what a declaration of war is, and the declare war clause doesn't say that Congress only has authority to issue pieces of paper that declare war. It's for Congress to decide whether we're going to wage war, at least under the original system. And many people said that. That's why Marshall said the whole power of war rests with Congress. If the question then is like, given that Congress isn't playing this role and the president is in effect using military force and or more generally waging war without congressional authorization, is the spending clause the only constraint? I think that ties back to the discussion of the War Powers Resolution, right, which is an attempt to constrain presidential war making without using the appropriations clause. So that's one mechanism that's out there, and of course it's not proven. Some might say it's proven a failure. You might wonder what the world would look like if there was no War Powers Resolution. That is to say, the question of whether the War Powers Resolution has failed or not is a function of how many more conflicts would be been engaged in without the War Powers Resolution. It's hard for people on the outside to answer that question because we're not privy to all the conversations where someone says, we can't do this because it'll run afoul of the War Powers Resolution, if in fact there are any such discussions. And then I think, if you don't think that the War Powers Resolution has had any effect, then I think the person asking the question has a good point that the only tool has been, to some extent, the appropriations power. And my recollection is it was used in the context of Vietnam. I don't know if it's been used since to try to halt a war, but it's an interesting point.
I see we're running a little short on time, but Mr. Engel, did you want to get the last word on that question?
Sure. No, well, I think from the standpoint of domestic law, authorizations for the use of military force are treated basically like, declarations of war. I mean, these are congressional statutes that, activate, with congressional support, the full war powers of the United States. And so, every one of those authorizations, of which there've been quite a few since World War II, I think provided sort of the domestic use of the declare war kind of statute, declare war power rather, under Article 1. When it comes to cutting off funding, the serious efforts were in Vietnam, and then they were in the second term of President George W. Bush with respect to Iraq. That never got through. But there were serious discussions in both Congress and in the Bush administration over threats to cut off funding, at the late time. And so it's definitely, it definitely is a tool that Congress can use. Part of the problem with some of the funding cuts is that they often happen where Congress has authorized the conflict, but doesn't have the will to pull down the conflict. And so there's efforts to try to sort of affect appropriations or to attach riders on existing appropriations and the like. So there are some complexities in that. But with all these things, and I think it's the same with the War Powers Resolution, these are political issues as well as legal issues. And the War Powers Resolution has influence on executive branch conduct, even if the executive branch doesn't fully accept, its constitutionality. I mean, people do track the deadlines, and they do talk about it, and that does shape conduct. And likewise, when it comes to discussions with appropriators or the like, that does shape conduct. President Bush, made the judgment to surge in Iraq, at the end of his term, but that was done against a backdrop of a lot of pressure from Congress, which certainly was, affecting things. So these things, a lot of these are not judicial questions that courts answer the legal questions definitively in some respect, but there is influence, and there are political debates that do have impact, including with respect to these legal restrictions.
Well, I'm going to turn things over to Caroline now, but before I do, just wanted to give a sincere thank you to both Professor Prakash and Mr. Engel for sharing their time with us today. Thank you so much for your contributions.
Great. Thanks, Nitin. On behalf of the Federalist Society, I want to thank our speakers for the benefit of their time and expertise today. Thank you also to the audience members who joined us. We greatly appreciate your participation. Check out our website, fedsoc.org, or follow us on all major social media platforms at FedSoc to stay up to date with announcements and upcoming webinars. Thank you once more for tuning in. And with that, we are adjourned.